Hi, I'm Jared McClain. I'm litigation counsel at New Civil Liberties Alliance, and I'd like to welcome you to our latest installment of our virtual Lunch and Law speaker series. Today's topic is hiding law behind a paywall. And before we get started today, we just wanted to present our brand new case video for Lisa Milice versus the Consumer Product Safety Commission, the case that we'll be discussing today.
So the day I found out I was going to be a mom was life-changing. So many emotions, from surprise and excitement to a slight bit of anxiety over the weight of that responsibility. I think one of my biggest concerns being a new mom, which I'm sure is that of any parent, is the desire to make the best, safest choices possible for your child.
Lisa Milice wanted to see the safety standards that apply to products like bath seats and playpens that Consumer Product Safety Commission adopts.
I found a summary of changes to a safety standard for infant bathtubs available on the same page that also lists the injuries, fatal and non-fatal, from use of bathtubs. And when I realized that the full standard wasn't available on that website, I called CPSC. They informed me that the standard was held with a third party.
If you look at the Consumer Product Safety Regulation, all the regulation says is we are adopting the safety standard for infant bath seats that has been set by ASTM. ASTM International is a nonprofit, and their business is developing safety standards. This is the safety standard that governs all these different child products. And if you're an interested parent concerned to see, do I need to buy the updated model? Can I get the old model? I have one for my prior kids. You have to pay money to this private organization to see what the law is.
They wanted me to pay about $60 for a safety standard when the tub that I was interested in purchasing was $35. When I was told I would have to purchase the safety standard, at first I was confused, and then I quickly became frustrated.
NCLA is representing Lisa Milice against the Consumer Product Safety Commission because the agency is trying to hide its rules behind a paywall. Anytime you're hiding a rule behind a paywall, you're making it harder for consumers to participate in the rulemaking process, and you're also making it impossible for them to figure out whether the safety standards that apply to a particular product are meaningful to them or not.
The way our republic is set up is the citizens are the government. So when the government makes a law, they're making it for the citizens. The government can't keep the law from the citizens because the citizens are the government.
It may be easier for the administrative state to outsource the rule writing process to safety organizations and standard writing organizations, but that doesn't mean they can hide the law from the rest of us.
I want to bring awareness to the general public that this information is held behind a paywall. And by partnering with NCLA, and I hope that by winning this case, we will be able to make those safety standards free to the public. It's important because it's the safety of our children at stake.
With us today, we have Nina Mendelson, who's the Joseph L. Sachs Collegiate Professor of Law at the University of Michigan Law School. Her wide-ranging scholarship includes 2 articles that are relevant to us today: Private Control Over Access to Public Law, The Perplexing Federal Regulatory Use of Private Standards, and Taking Public Access to Law Seriously, The Problem of Private Control Over the Availability of Private Standards. She's also participated as amicus curiae in several cases relating to incorporation by reference and public access to the law. And also with us today is Adina Rosenbaum, who's an attorney at the Public Citizen Litigation Group, where her litigation practice focuses on consumer law, access to justice, open government, administrative law, and the federal courts. Adina has argued cases before the Supreme Court and several federal courts of appeal, and for our purposes today, she's also filed amicus briefs in the federal courts in a few different cases in which public access to law was at issue. Adina and Professor Mendelson, thank you both for being here.
Thanks for having us.
Yeah, I guess as a bit of background, NCLA filed a case in the Third Circuit, which is now in the DC Circuit, challenging the Consumer Product Safety Commission's use of incorporation by reference. And sort of to get us started on how we got here, Professor Mendelson, could you start us off with a quick overview of the history of the government making law publicly accessible to its citizens?
Right. So, first again, thanks for including me in this discussion. I'm very happy to be here. Problem is, it's the plaintiff in this case. It wants to see infant bath seat safety standards and is unable to access them without paying to see the standard. And that's because the Consumer Product Safety Commission, instead of publishing this standard itself, simply incorporated a privately drafted standard by reference and then asked interested parties to go ahead and ask the private drafting organization to see the standard, which is where she ran into trouble. So this is the problem of incorporation by reference or so-called IBR standards. And to introduce this, this is really an enormous contrast with the rest of the expectations that we have for public access to the law. Since 1795, Congress has made printing of the laws a public function, and we've had a steady, march towards greater public access to the text of our federal law, whether that's statutes or regulations. We have a depository library system at the federal level that's been in place since 1817. Since the 1800s, you've been able to get access to the paper copies of statutes and regulations without charge. Of course, the Federal Register Act was passed in 1935. That provided for public printing of all regulations. And again, those went to depository libraries. And then in 1993, Congress provided for universal online access to all federal statutes and regulations. And then that was followed by the E-Government Act in 2002, providing for free online access to the regulatory process. That's the regulations.gov website, which many of you may know of. The only exception to all of this free public access to the text of our statutes and regulations at the federal level is incorporation by reference rules. That's the only exception. So for these, if you want, what you see when you look in the Code of Federal Registers for these, close to 10,000 standards, instead of seeing the text of the federal rule, like you do for every other federal rule, you instead see a number and the name and address of the organization that issued the privately drafted standard that the federal agency has chosen to rely upon. It's then on you to reach out to that organization to try to locate the standard and see if you can get access to it. And I know Jared will cover this, but many times these regulations or these privately drafted standards are difficult to locate, and you have to pay if you want to read them.
Adina, let me bring you in to sort of let us know how we got here. How did incorporation by reference become a thing that is now the exception to all that free access to law that Professor Mendelson outlined?
Sure, and thanks for having me here. So the purpose of incorporation by reference is that if you have a standard and it's very long, it might make the copy of the Code of Federal Regulations just be very long. And so in order to sort of make the, to make the physical copy of the book shorter and sort of more accessible, agencies started incorporating things by reference. So this is basically to save paper. It's meant to be something that is practicable and not an excuse to, or a means of having law not be accessible to the public. And the ability to incorporate by things by reference into regulations is recognized by law, particularly in the Freedom of Information Act, FOIA. And when we think about FOIA, we often think about the part that requires agencies to make records available if they're requested, but that's just one part of FOIA. The first part of FOIA requires agencies to publish various things in the Federal Register, including substantive rules of general applicability. And then it says that except to the extent that a person has actual notice of something that should be in the Federal Register, a person may not be required to resort to or be adversely affected by a matter that's required to be published in the Federal Register that's not so published. So if something is required to be in the Federal Register and isn't someone can't be required to abide by it unless they're given actual notice of it. Where incorporation by reference comes in is that FOIA then states that matter reasonably available to the class of persons affected thereby is deemed published in the Federal Register when incorporated by reference therein with the approval of the Director of the Federal Register. And what I really want to focus on in this language is that in order to be incorporated by reference, the information or the part of the regulation has to be reasonably available to the class of persons affected thereby. And this is language that's been in FOIA from its beginning in 1966. Now, the statute doesn't define what it means to be reasonably available. But there are, as Professor Mendelson has already mentioned, there are other statutes that require laws to be free and available online to the public. And FOIA itself does have some language about that with respect to other information. So information that's not the law to quite the same extent as the rules required to be published in the Federal Register. So things like interpretations or staff manuals, FOIA requires those to be made public as well and requires them to be put in a reading room. And since 1996, when Congress passed e-FOIA amendments, those reading rooms have to be electronic and are online. So in 1996, it was a little unclear that it had to be online, but how that's understood today is that that information is freely available in online reading rooms. So FOIA itself makes clear that when we're talking about making things accessible to the public, we're talking about electronically. To be incorporated by reference, the Director of the Federal Register does have to approve the incorporation. And one might think that that would be a place where the Federal Register could come up with standards of what it means to be reasonably available. And the Office of the Federal Register did do a rulemaking on this that concluded in 2014. And various commenters on that rulemaking did make this point that to be reasonably available, information should be freely available online, easily accessible the way in this day and age we certainly expect laws to be freely available and easily accessible, but the way in this day and age we expect many things to be freely available online. But the Office of the Federal Register did not adopt that interpretation. And instead, for the office to approve something being incorporated by reference, they require that in the preamble of the proposed rule that the agency discuss how it proposes to make the information reasonably available, or how it worked to make those materials reasonably available, and to summarize the material it proposes to incorporate by reference. And again, in the final rules, it requires for final rules that the agency discuss how they're reasonably available to interested parties, and again, to summarize the material that's incorporated by reference. But it doesn't actually set any standards about what it means to be reasonably available. And again, certainly doesn't set a standard requiring the information to be freely available online the way we expect, how we would interpret reasonably available to mean in this day and age.
Right, because the law that was passed that allowed incorporation by reference in the first place was passed in what you said, 1966?
FOIA is from 1966.
Right, so there wasn't, the internet was not in mind when they were passing these laws, and what is reasonable could presumably change over time as it becomes easier to disseminate information.
They do require a copy of the standard to be given to the Office of the Federal Register to incorporate it by reference. But something I think we'll be discussing is that even though they have a copy, sometimes they don't seem to have a copy after some time has passed. And even if they do, that doesn't mean they're willing to show it to other people.
Right. And just to close the loop on that, one of the things we saw in Lisa Milice's case is that agencies are using this Office of Federal Register rule as a shield against making their rules available. For instance, the Consumer Product Safety Commission said that because OFR said that all they have to do is provide a summary, they've interpreted that OFR rule to mean that they're forbidden from publishing a copy of the rule, which is not what the Office of Federal Register said at all. And what the Consumer Product Safety Commission does is make you travel to their physical reading room in Bethesda, Maryland, to see what the standard is. And even when you're there, you can't take a picture, you can't make a copy, you just have to memorize what these lengthy and technical safety standards are. And I think that that sort of leads us into the practical problems that IBR has created. Professor Mendelson, when you and I first spoke last spring, you were telling me about the online reading rooms that some of these private standard setting organizations have created and the different practical problems that create. Could you sort of touch on that and fill us in there?
Yeah, sure. And I just want to emphasize a point that I think has been sort of implicit in the comments and which Clegg has raised in the chat, which is that these privately drafted standards, once a federal agency chooses to incorporate them, they have the same legal status as any federal regulations, meaning that sanctions can follow if you don't comply with them. So again, it's important to emphasize that these are claimed to have exactly the same force of law as any other federal regulation, even though they are often behind a paywall. So how do you see these things? Lisa Milice, had to contend with the in-person reading room at the Consumer Product Safety Commission. Those kinds of in-person reading rooms provided by the agencies obviously are not going to be an option for the vast majority of people in this country. So if you are not a person who can drive to Bethesda, Maryland, or to a reading room in Washington, D.C., what are your other options? Basically, you have to, if you want to see the standard, you have to accept whatever terms the drafting organization sets. And sometimes drafting organizations charge quite a large fee for these standards. I think the ASTM standard here costs $56, is that right?
58, but right there now.
Yeah, other ASTM standards can cost hundreds of dollars. American Society for Mechanical Engineers standards can cost thousands of dollars. These standards development organizations have responded to complaints by creating online reading rooms, which I think is what Jared is referring to. And the online reading rooms sound like they could be a great solution because you don't actually have to pay money to access them. But there's some quite significant problems. One is you have to find them. They are often very difficult to find. But even after you find them, the standards drafting organizations usually require oppressive conditions to see the standards. I can see a question in the Q&As. You have to identify yourself and provide your email. That's one thing. But past that, they usually require, actually all of the reading rooms I know of require you to sign a release or even a license before you can see the text of the standards. You may have to agree that essentially you have no rights in a dispute against the organization. You promise not to exploit the standard in any way or to use the standard in any way. If you're a citizen and you want to write an agency about a bad standard, that's a pretty significant limitation on your ability to engage in that core conduct. Several of the online reading rooms require you to sign indemnification clauses that are very vague, that somehow you're going to indemnify the organization for some claim they may have against you. And they also provide for forum selection clauses. So if there's a dispute with the organization, you promise to travel to Pennsylvania or Massachusetts. These are pretty onerous conditions to be able to see the text of the binding law, but they're absolutely required if you want to see it through these free, these online reading rooms without actually paying the fee. The only other alternative is to pay the fee or to travel to a Washington, D.C. area reading room to see the text of the standard. The last thing I'll say about it is, even if you click through all these licenses, you agree to the indemnification clause, you agree to the forum selection clause, the way access is provided is very limiting. You can't cut and paste any part of the standard. You can't save it to read later. If you're a citizen and you want to understand what the infant bath seat safety standards are, or you want to write the CPSC and say standards should be different, or you want to write your member of Congress, these kinds of limits really impair your ability to deal with the text. And of course, right now, with our courts the way they are, the text of the law really matters. And so access to the text is critical, and it's really not adequate in these settings.
Right. So basically, you can either travel to Bethesda, Maryland up front, or go through all these licensees, be accused of exploiting the standard, and then travel to Pennsylvania after the fact and litigate your rights then.
Or pay the fee, whatever fee the organization chooses to set. And there is no limitation on the fee they can set. They have complete latitude to set the fee and even to revoke access altogether.
Yeah, what the eye-catching ones, I know that there were some like nuclear standards that cost thousands and thousands of dollars, but the one that stood out to me was the standard for what bottled water can be called purified water costs $850 to see. So if you just want to know what the water you're drinking consists of, you have to pay $850. Adina, was there anything that you wanted to chime in with on practical problems?
I think that mostly covers it. Just that accessing these standards sometimes involves giving up other rights, like waiving other legal rights in order to try to access the law. And sometimes a rule, you talked about the nuclear one, sometimes a rule can incorporate a whole bunch of different standards. So it can end up, or someone trying to follow the law can be regulated by a whole bunch of different standards. So even if each specific one is $65, and that doesn't sound like a huge amount of money, if you're trying to figure out the law that's binding you or the standards that are applying to all of the baby products that you want to use, it can really start adding up.
Yeah, and that just reminded me, I believe one of those, the Nuclear Commission incorporated an entire book of standards that cost thousands of dollars, and that book is now out of print. And so you just can't even purchase it. And that's one of the other practical problems is all these limitations that Professor Mendelson is outlining, those limitations are set by a private organization. And the system that OFR and the Consumer Product Safety Commission have created makes us reliant on these private organizations to determine when we can see the law, how much it will cost, and what the limitations are. And I think that's also just part of the problem.
There was a
sorry, go ahead.
case, I was just going to say on the topic of practical problems, there was a case that we might have already mentioned in the DC Circuit where an organization put some standards online to make them access to the law and was sued for copyright infringement. And one of the instances that they cited in one of their briefs was a case where the standard was relevant to the case and the judge asked for a copy of it. And the government agency actually said, because of copyright, we can't give you a copy of this. We can't file it, and instead wanted the court employee to come down to the agency. And according to the brief in this case, the way that I wasn't able to access the underlying case, but according to the brief, the way that the judge, that the court actually ended up getting a copy of the standard was by going to the website of this organization that was making them available online. So of the nonprofit that was being sued for making them available online.
Yeah, and stories like that, and I think the pressure that's beginning to mount in the past 6 or 7 years has sort of changed the tone of these standard setting organizations. I know ASTM is still showing up in court and saying they have a right to keep these private, but in response to the Milice suit, all of the Consumer Product Safety Commission ones are now in their reading room for free only after they've already become a binding standard. So during the rulemaking process, you're not allowed to see them for free, but once it has become incorporated, they'll let you see them, but there's nothing keeping them from revoking that privilege at any time. And yes, that sort of brings us into another legal issue that the practical problems present, and that's during the notice and comment rulemaking period, that's the only chance that consumers or manufacturers have to relay their concerns to the agency about the efficacy of a proposed standard. And if the proposed standard's not available, the proposed revision's not available and the prior version's not available, you have to purchase two versions in order to see how the law is changing. And the ASTM is nice enough to offer a red line version that compares the proposed rule to the prior version of the rule. The problem is that after you fork over $69 to see this red line, you find out that they're comparing it to a prior version that was never incorporated into law. And so they're comparing the proposed version to an intermediate version that was never incorporated, and it tells you absolutely nothing about how the proposed version compares to the prior standard. And then you're out $70 and have no useful information. And all you're left to rely on is the summary that the agency provides you. And in Lisa's case, the CPSC stated that the 2019 standard corrected dimensioning errors in the 2013 standard, which had caused bath seats to fail from the way they made contact with the tub. This tells affected persons next to nothing. We don't know what those errors were, what the magnitude or effect of the errors were, what the new dimensions are, what type of contacts with the tub led the bath seat to fail, how often the failure was. So it goes back to the point I believe Adina was making earlier about OFR lets these agencies just give you a summary, but there's no sort of guidance or rigid requirement about what this summary actually has to illuminate. And with that, I think it leads us into how we change the system. And sadly, since OFR didn't respond to the public rulemaking, I think it has to be done through court. And Adina, could you start us off with sort of the statutory challenges to IBR?
Sure, and I just want to note that, I think you've talked a little bit about the notice and comment problem. And it's interesting because courts, I feel like agencies do this very differently, where I've seen sometimes the opposite, where an agency will make the standards available during notice and comment rulemaking so they can be commented on. And then once they become law, we'll suddenly make them no longer available. And I think it's important that they be available at that point also. The APA, in addition to giving people the right to comment on proposed rules, there's also the right to sue over rules that have been enacted. And without having access to what the law being enacted is, it's impossible to know whether the explanation given by the agency during the rulemaking explains what rule they decided on, or to otherwise sort of challenge the rule as illegal. It also makes it hard to, there's the right to petition an agency to change the law, and it's hard to petition for a change when you don't actually know what it is that you're changing. Or it makes it harder to play a role in enforcement. So, if someone wants to let an agency know about a particular product that they've discovered is actually violating what the standards in place are, it's useful to know what the standards are in order to be able to, either enforce them yourselves or to go to the agency that has enforcement power and say, here, there's a real problem in this instance, and we need your help enforcing it. So again, I think that where one area really is for challenge is in this reasonably available language. So the Freedom of Information Act requires or says that standards can be incorporated by reference, but in order to be incorporated, they have to be reasonably available for the class of affected individuals. And so it comes down to what does reasonably available mean, and given how, given the other laws and expectations that law will be made available, and just given how easily accessible things are online, I think that the best interpretation of what reasonably available means today is that something should be free, freely available online for everyone to be able to access.
Right. And I know in our briefing in Lisa's case, the CPSC pushed back and was like, oh, well, that language was adopted in 1966 and there was no internet. So basically we're allowed to stay in the Stone Age and never move forward and make the law more available than it was back then. And I mean, yeah.
I think what's reasonable can change. I mean, you know, even back then, I would think that you would want people to be able to access incorporated by reference standards the same way that they access other laws. And the way we access other laws have changed in the last 50 years.
Right, as Professor Mendelson pointed out when we got going, there's the depository libraries, there's basically every other law is freely available online now, except, and I think in your briefing and Professor Mendelson's scholarship, there's upward toward 10,000 IBR standards now. I think it's 9,500, correct me if I'm wrong, Professor Mendelson?
Right, based on scholarship by Emily Bremer, who's a professor at Notre Dame, she calculates close to 10,000 incorporated by reference standards. And again, even if reasonably available in 1966 didn't mean the internet, you know, even then we had over 1,000 government depository libraries where all the rest of the laws were available. All the rest of the text of statutes and regulations were available. And it seems reasonable to say that when you're talking about text with the force of law, it at least has to be available in the same way as all the other laws.
And I think it's important too to remember that this whole time we've been talking about the Freedom of Information Act, and courts, the Supreme Court in particular, has said that this law needs the law needs to be interpreted broadly when you're talking about making information available to the public. And if there's an exception, that exception needs to be interpreted narrowly. And to the extent that IBR is an exception to making the law freely available, that needs to be a narrow exception. And I think Adina said when we were getting started that the whole reason we got this in the first place is because the physical copies of the Federal Register were getting too large. So the purpose of the law would still be served if you're making the law freely available on the internet, because you can have a less bulky physical copy that isn't going to take up thousands of bookshelves at these depository libraries while still providing the public access to the law. And then aside from the statutory arguments under the APA, there's also some constitutional concerns that I think Professor Mendelson has also outlined in her scholarship. If you want to sort of touch on some of these.
Sure. I actually want to chime in on one of the statutory issues, and then I'll mention the constitutional issues. So, you know, Adina correctly pointed out that you know, there's a huge issue with reasonable availability, and then Section 553 also gives you the right to petition to change a rule and to a right to comment meaningfully on the text of a proposed rule while the agency is considering it. And even if the standards drafting organization does make the text of the standard available without charge, they almost always, in fact, I don't know of an exception, still require these onerous licenses and releases to see that text. So even if you're not paying out cash, you are still agreeing to some very burdensome and costly provisions. So I did want to underscore that. In terms of the constitutional questions, this is really interesting because I think we think of free access to the text of the law as essential to core democratic principles. And you know, that said, there is not text in the Constitution that says the law shall be free. Even so, there's a long history behind this. There's from authoritative Roman histories, there are stories about, you know, Emperor Caligula of Rome posting tax statutes in teeny tiny type on the top of very high pillars so that you couldn't see the text, and then imposing sanctions for violating them. And that's kind of a key story in our understanding of what it means for us to be governed in a democracy. And that story has definitely been quoted by judges, including Justice Scalia. And we might also say that it's just critical to other important aspects of the Constitution. Of course, the due process clause gives you the right to know the law before you're subjected to sanctions for violating it. that supports a notion that you should be able to see the law without charge. And the First Amendment is the other big source of a constitutional right here, because the First Amendment preserves the right to criticize the government and to approach the government and argue for change. And you can't do that effectively when you're talking about the law if you can't readily see the text of the law. So again, the courts have not specifically reached these issues, although the Supreme Court did declare in a case decided last spring, Georgia versus publicresource.org, that, they declared no one can own the law. They just said that's just an article of faith. And it is possible that that will be the line that they will take going forward in terms of constitutional protections in this area.
Yeah, and there was a lot. So just as a little background, the Georgia versus Public Resource case, the Georgia legislature had hired LexisNexis to write an annotated version of its statutes. And basically for a licensing agreement, Lexis maintained ownership over the annotated version. And so you could see what the statutes were for free, but you couldn't see the annotations. And the factual record of the case basically pointed out that there were important things in those annotations about to know how the law would apply to you. And Chief Justice Roberts sort of not necessarily went out of his way, but it wasn't squarely the question presented. But as Professor Mendelson said, he said no one can own the law. The cases that he was citing for this were back to the 1860s and 1880s. And he said, if you were allowed to own the law, we might end up in a situation where we have a pay-per-law service. And we've argued in our briefing in the Milice case that that's exactly what IBR has created, because if you want to see the law, you have to pay for each copy. And so although there hasn't been many opinions squarely on point, and I think ours is the first directly attacking the IBR, that there's a lot of helpful language out there, and the cases have been coming at it from a different angle. But the problem also is, I guess it's not a problem, but part of the reason that the constitutional law, I think, hasn't developed as much is because on the statutory issues that Adina was referring to earlier, the cases have been sort of saying, well, the statute must mean that the law needs to be available, or else we'd run into all these thorny constitutional issues that nobody's talked about yet. And Adina, could you sort of tell us what, I know you participated as amicus in the Astm versus public resource case. A lot of these are public resource because the guy from public resource just posts all this stuff online and then waits for the challenge to come. But yeah, could you sort of tell us what happened in the DC circuit?
Sure, and I actually want to sort of mention first one of the kind of seminal cases on these issues is actually a Fifth Circuit case called Veek that was from 2002, an en banc case, because a lot of these cases end up turning on questions of copyright and the extent to which standards maintain their copyright. And in Veek, the Fifth Circuit, in that case, two towns in Texas had adopted a model building code as their building codes. And the operator of a non-commercial website had bought the model building code and then posted it online as being the building code for these two towns. And the question was whether this violated copyright. And the court held that as law, the model codes were not subject to copyright, but that as a model code, it still had protected status. So if it was posted online saying this is the model code, that could violate copyright. But if it was posted online saying these are the building codes of these two towns, which was true and which was how it was posted, that did not violate copyright. The court, though, did to some extent distinguish between the model code and incorporated by reference standards, talking about whether the standard was developed specifically to be incorporated by reference, whether they had solicited it, and whether the law required, actually adopted it as law or required just looking at it. And because the Veek did somewhat distinguish or left room for that distinction, when the Office of Federal Register came up with its rule, it said, well, it relied partially on that to say that there may still be copyright considerations. Moving ahead to the ASTM versus public resource case. In that case, this nonprofit had bought standards and put them online and was sued for copyright infringement. And the district court granted summary judgment to the standard setting organizations, and it went up to the DC Circuit, which decided to avoid the constitutional issue about whether incorporated by reference standards whether there could be private ownership of those standards, and instead remanded to the district court for to weigh the fair use factors under copyright differently. Judge Katsas had a concurrence in that case that actually talked about putting the law high up on the wall, and more directly says that access to the law cannot be conditioned on the consent of a private party. And then he concurs, finding that the fair discussion of fair use in the majority's opinion, he says, puts a heavy thumb on the scale in favor of an unrestrained ability to say what the law is. So he seems to think that applying the fair use factors to standards that are, actually constitute the law is going to be fair use, and that those will not be protected by copyright, and concurs with that understanding.
Right. And yeah, and on that point, I think there've been a couple other cases that have come out recently. I know lawyers and journalists alike sort of have become to loathe PACER because you have to pay 5 cents a page, 10 cents a page, but when those fees also begin to add up, and to see what judicial opinions and judicial filings are. And the Federal Circuit also recently remanded a case saying, not quite getting to the constitutional thing, but saying we need to have access to the law. And I believe Public Citizen just had a case in the Second Circuit get decided on whether the BIA, Bureau of Immigration Affairs,
Appeals, I think.
Appeals, Bureau of Immigration Appeals had to make its unpublished, unreported decisions available. And I think part of the problem there was they said their defense was, well, like they're not binding law, so they don't need to be available, except the record showed that the BIA themselves often relies on the unreported decisions that are not available to the defendants. So it created an imbalance between the power of the government in prosecution and the power of the defendants. And the Second Circuit said, you guys need to make these available. I believe they remanded and said, trial court, you can figure out how they are going to go about doing this.
I think that case is important both for the actual records that were at issue, which was these non-presidential decisions, but where the Bureau could, knew about them to rely on them in cases, but other people couldn't access them. But the actual holding in that case, which is also interesting, was about the remedial scope of FOIA and about the extent to which judges, there is this part of FOIA that requires various things to be put online. And the agency was taking the position that FOIA didn't allow as a remedy for judges to order agencies to comply with that provision. Just all that judges could order is that records be given directly to people who requested them. And so part of the holding of the case is that that judges can order things to be put online, because that's what FOIA requires is, it went through the text and the statutory construction, all of that, but it also recognized that, that's what Congress had required in this instance, was for those types of records to be made available to the public affirmatively, not just in response to a request, and was giving meaning to that requirement.
Yeah. And we mentioned how sort of the copyright and the constitutional and statutory issues are often intertwined, and in Milice versus CPSC, they're really not. We're just addressing the whether the law should be free head on. But as both of you know, because you've filed an amicus brief in the case, ASTM has also stepped in and said, wait, this is a copyright case, and you guys can't infringe our copyright, and we need this money to survive. Meanwhile, they hired big law corporate counsel to come in and request argument time to argue, and we're waiting to see sort of what comes of that. We argued that this is not a case about copyright law. ASTM has no reason to be showing up for argument time, but then the Third Circuit, after a bit of a delay and some jurisdictional briefing, decided that we had to transfer the case to the DC Circuit, and they said, our colleagues in the DC Circuit can decide whether ASTM has a say in this case. So we're still waiting to see what comes out on that. I just want to point out to the attendees that use your question and answer function. In a couple moments, we're going to turn to Q&A if you have any questions you want to get in. And before we do, yeah, Nina, do you?
Yeah, since copyright has now come up a few times, I thought it would be worth pointing out, an aspect of the complexity of this problem that we really haven't tackled yet, which is, these standards are undeniably often useful to the government. It's often useful to the government to pick up these private standards and make them part of federal law. The CPSC probably felt it needed an infant bath safety standard, and instead of having to put the resources into it, it scooped up this private standard and decided to make that the content of federal law instead. From our perspective, it's critical for citizens, bath seat manufacturers, everybody to be able to see the text of the law for compliance reasons, for consumer decision reasons, and for reasons of holding the government accountable for the law that it chooses. But private organizations also might say, look, we're doing something of value here. You can't just take that for free. That's their perspective. It's quite complicated. For some organizations, like the American Society for Mechanical Engineers, I think they're sort of indifferent as to whether the government picks up their standard. Others, like the American Petroleum Institute, will go to the government and say, use our standards when you decide what a deep water oil well has to be able to withstand. They advocate for their standards. And they're made up of it's a trade association that is specifically has the mission to speak for the oil and gas industry. So perspectives vary, but some organizations would say, look, we're contributing something of value here. You can't just give it away for free. I think the point to make is the way to work through this problem should not be for consumers to have to pay to see the law. That can't be the right answer. There may be other ways to make sure that private standard organizations receive some funding if that's what they need. Agencies already supply funding and personnel to these organizations. Perhaps there needs to be more of a negotiation on that. But there is another interest here. I think the main point that I appreciate about the way this lawsuit is being brought is this particular aspect of the problem can't be worked out by asking people to pay to see the text of the law.
Right, and yeah, I know it's a little glib, but the agencies did create these standards, and they did have a copyright interest in them. And not only did CPS choose to adopt their standards, but the statute requires CPSC to either adopt the private standard or create a more stringent standard themselves. So the alternative to CPSC is basically choosing to do this rather than creating a more stringent standard themselves, which is always an option to them. And like you said, that would come at a cost. And maybe the solution is to take some of the money that would have gone into that cost and purchase a license to the standard. But what we pointed out, and in Lisa Milice's case, is that's a question between CPSC and ASTM, and that has nothing to do with whether Lisa Milice as a new mother should have access to the safety standards that govern the products that she's buying for her child.
I think that's the right answer, and I hope you succeed in persuading the DC Circuit that it's the right answer.
Thank you. Yeah, it's about that time, so we'll turn to the question and answer. I see there's a few queued up in the chat. The first one says, in the case out of Georgia, the Supreme Court concluded that the state statutes and regulations enjoy no copyright protection. Does that case have any bearing on FOIA's IBR provision? We sure hope so. Do either of you have a more nuanced take on that?
I can, or if Adina, if you prefer.
Go ahead.
Okay, so this is Georgia versus publicresource.org. It's already come up in the conversation today, and it was a challenge to this nonprofit, publicresource.org, out in California. They posted Georgia's annotated statutes online and got sued for copyright infringement. What the court held was that the annotations were government edicts, because they'd been authored by the legislature, and even though the legislature had essentially done work for hire here by hiring Lexis to draft the annotations, they were still authored by the legislature. And the court's holding was that, you know, government edicts cannot be copyrighted. That's a longstanding copyright doctrine. And in the course of announcing that government edicts, of course, could not be copyrighted, and they covered these annotations, they also said no one can own the law. Now, again, that's in the context of a copyright case, but I think it has obvious relevance to this litigation.
Awesome. And Kim Courtney asked, the Uniform Fire Code created by NFPA is incorporated by reference into the Massachusetts Fire Code and likely lots of other states, but is only accessible online by signing up with your email address. Even though there's no fee, do you think that the email requirement could be challenged? Is this enough of a constitutional impediment to access to the law? Do either of you two have any thoughts? I'm not familiar with this specific practice, or if sometimes when you submit your email, you're also agreeing to some terms.
I think this is, you know, I can't say for sure whether revealing your identity is the violation of your right to free speech, but I certainly can say that this is one of many conditions you have to agree to access those NFPA rules. I was actually online looking at them myself yesterday, because there's a debate about firefighters' protective gear and whether it contains carcinogenic material as a result of NFPA standards. You have to give up a lot of your legal rights to access the law. I think anonymity or not, that alone is a burden on your right to see the law, and that implicates First Amendment rights for sure.
I also think that for some of these, and I don't think I've looked specifically at the NFPA, what they tell you when you put in your email address, but I think for some of the others, you're agreeing to get some marketing from them. You know, they now have access to your email, and when people have access to your email, that's valuable to them. So it is, you know, right, giving something away.
That's a really good point, because we think about things that are free to us online as not having a cost, but stuff that's free to us online is a multi-billion-dollar industry. So there is a value there. Next question is, you mentioned question from Paul, sorry. You mentioned being able to remedy this unfortunate situation through court action since the Office of Federal Register hasn't done anything. Is there a reasonable chance of congressional action? Are there any groups that are actively lobbying for legislation requiring open access to all laws? Do either of you know of any congressional efforts? Yeah.
Not presently. There was an effort several years ago with respect to pipeline standards, but that did not end up making substantial progress. And in part, that was because the agencies argued we have to have some standards, and we can't. This is how we want to do it.
Yeah, and I think one unfortunate part of where we are and how these things tend to work out is Congress has passed a lot of laws saying that the text of laws and statutes and rules need to be publicly available, and then the agencies don't comply. And it's really tough to rely on Congress to keep acting in response every time an agency isn't doing what it should be doing.
In addition, I think there's an argument to be made that the law already essentially requires free access here. That's the argument you're trying to vindicate. If you win, there's not going to be a need for more legislation.
Right. Our next question from Rachel says, when did you file Lisa Milice's case? What's the status of that complaint? We filed our petition to review. Basically, it's a petition to review an agency rulemaking, and you're able to file those directly in the courts of appeal. And we filed our petition, I believe, February 15th of 2020. We briefed the case in May. Our briefing was concluded by June. The court put it on the oral argument calendar for the end of October 2020. And there was this line in the Consumer Product Safety Commission's brief that was like, maybe this isn't the court we're supposed to be in. And that's all they really said. They didn't make any sort of full-throated argument that there was no jurisdiction in the Third Circuit. And about 2 weeks before oral argument in October, the court pulled the case from the argument calendar and said we would like supplemental briefing from both parties on whether the Third Circuit has jurisdiction or whether this case needs to be transferred to the DC Circuit. And the reason that arose is, I believe in 1996, there was a Consumer Product Safety Improvement Act passed by Congress that required CPSC to pass lots and lots of new safety standards. And there were some for ATVs, there were all the durable nursery safety products, and then there were a few other categories. And they had a short timeline, basically 18 months to 2 years to promulgate all of these new standards. And this Consumer Product Safety Improvement Act provided that all of these new standards that got published on this expedited timeline would have an expedited review process. So rather than the normal review process that applies to any other rulemaking you're challenging from CPSC, these will go directly to the DC Circuit on expedited review. And this nursery standard, the bath seat rule that Lisa Milice is challenging, was originally promulgated back then in response to that new statute, and it's been revised over the years. And so Lisa is just challenging a revision to that rule. And what the statute also says is, if CPSC revises one of these rules, that revision will be treated like a normal CPSC rulemaking. So our interpretation of that statute, which we still think was the right one, is that since that rulemaking was to be treated like all other CPSC rulemakings, Lisa Milice should have been able to go to her local court of appeals and challenge that rulemaking. But ironically, what the Third Circuit said was, if you want to challenge this practice by which CPSC makes you drive to Washington, DC to see what the law is, you need to go to the DC Circuit to challenge that rule. And so that's where we are. That ruling came out from the Third Circuit last week while we were preparing for this and while I was preparing for the oral argument that was scheduled for 4 days from now. And the case has since been transferred to the DC Circuit and it's been docketed, and we're sort of waiting to find out what the next steps are, whether the DC Circuit's going to require more briefing or what. And so we're sort of in a holding pattern waiting to see what the DC Circuit wants from us. But hopefully we'll get an argument in the DC Circuit soon and then a forthcoming decision. So that's where Lisa's case stands. Next question is from an anonymous attendee. They ask, under the Americans with Disabilities Act and the state ADA counterparts, small businesses are supposed to know what the current standards, manual, or model building codes look like, but state ADAs incorporate the federal standards by reference, and the federal standards incorporate private standards by reference. So you have a bit of an inception IPR problem. How could one challenge that sort of double IBR? Do either of you two want to take a crack at that?
Well, I think the attendee is raising the prospect this is also an Americans with Disabilities Act violation. I'm not in a position to assess that, but it certainly seems worth looking at. If they actually require that small businesses need to know what the building codes are for this, then having these standards behind a paywall creates a real problem there.
And I think this sort of highlights sort of two practical problems that we didn't really touch on. One is just that there is a burden on small businesses here, that small businesses, if they need to comply with a bunch of laws or a bunch of incorporated by reference regulations, again, that can add up in terms of cost. And then on the flip side, various of the examples I've seen of people who've been unable to access the standards that are governing them are, people who are being affected by businesses or other places not complying with accessibility standards. So there were comments on the rulemaking, the Federal Register's rulemaking from a legal services organization that works with people in nursing homes that was talking about, if someone in a wheelchair can't get through their nursing home door and wants to know whether the nursing home is complying with regulations about being accessible and about what the width of a doorway needs to be, that if someone's on Medicare and living in a nursing home, they're not going to be able to afford to be able necessarily to access the relevant standards. I think another place where sort of disability issues comes into play here is that when standards are posted online in some of the formats in which they're posted can make them, once you've gone through giving up whatever rights you're giving up to click through to see the posted online standards on standards organizations' websites, they're not always posted in a way that makes them accessible to people with disabilities. So that can also be a limit. So I think there's actually a lot of ways in which this issue overlaps with issues about disabilities and people with disabilities having access in different ways.
Yeah, and there was that comment on the OFR rulemaking from, I believe it was Vermont Legal Aid, and then there was one from New York City's Environmental Protection Agency that had similar concerns that they have to comply with all of these standards themselves, and local municipalities that have to comply don't have access. And I guess they just have to factor that into their budget and purchase all these standards from private organizations right now.
And even just to add to that, a number of small business organizations also filed comments saying that they were impaired in figuring out their legal obligations. The National Tank Truck Carriers filed a comment. The people who make airplane parts filed a comment saying, look, we have lots of obligations under these rules. We can't figure out what they are because we have to pay to get access to them. And that is a huge practical problem as a result of this system.
Yeah, and our next question, more of a comment from Mark, is wouldn't one solution here be to make private standards strongly recommended instead of mandatory? Perhaps the mandate could be limited to saying on the package or labeling whether the applicable private standard has been followed or not. And I think that happens a lot on like food stuff. You can sort of say that your product is organic or vegan, but there's not actually, so you can market that way. And I think that highlights something that Nina was getting to earlier that we sort of was implicit in the conversation and we hadn't really said out loud at first, was due process requires to know what the law is because these standards are binding law. And Mark's suggestion would relieve that if it's not binding law, we no longer need have the due process concerns.
I don't think that's quite right, because if you are a small business making toys and you have to put on your product whether it complies with ASTM F96317, which is a toy safety standard that happens to incorporate about 15 other toy safety standards, for you to be able to make a representation like that on that product, you still have to be able to see the standard. For consumers to know what that disclosure even means, you still have to be able to see that standard. And so a mandate that's about information disclosure still requires access to the text of the standard. Could the government just do nothing with these standards at all? Yeah, then they would no longer be binding law in any sense, but that wasn't my sense of the question.
And we have a comment from Kim Courtney. It just hit me that some of these regulations have criminal penalties, so there's another constitutional angle to it. And I think, I know from NCLA's own litigation, not in the Lisa Milice case, but in some other cases, we have that even though not all of these standards carry criminal penalties, the fact that some of them do, and they're all relying on the reasonably available language, that would require the courts to be interpreting what's reasonable available through the rule of lenity in order to make sure that we're not imposing criminal penalties on people who haven't been able to see what the law is. And that would the rule of lenity is basically almost tie goes to the defendant, because if it's ambiguous about what the law is requiring, we need to interpret it in a way that is more lenient on defendants.
I think the criminal penalty is also just underscore what we're talking about here is law. Like, this is the law that binds people and that governs, and just really underscores the importance of the standards that we're talking about. And, we can sort of, I feel like we say you need to know what the law is, people need to have access to the law, but it really just underscores how important, law is binding on people, and how important it is that we know what it is.
Right. We have two more a comment and a question. I think that we have 3 minutes we might be able to get through first. I'll go through the one real quick. It says President Trump signed the executive orders, I think it's 13891 and 13892, saying all guidance, if the agency wishes it to have force and effective law, must be available on the agency's website. Biden has since revoked those executive orders. Does that revocation affect Lisa Milice's case or the debate on IBR? Ironically, that's about guidance, which does not have, which does not carry the same force as rules that have gone through rulemaking. And so what we're dealing with in Lisa's case is a bit worse than the unpublished guidance from that perspective.
I'll just add to that agencies were already required to make their guidances available online. This doesn't change that. That executive order, which did have a useful aspect to it, required kind of a centralized portal for guidance. But my understanding is most of the agencies are doing that anyway. And as Jared says, these guidances can't have the force and effect of law to be legitimate guidances.
And I think we have time for probably one more. It says from another anonymous attendee, it says there is one aspect of IBR that's interesting. Hopefully more than one, since we filled an hour and 15 minutes now. But one reason industry groups advocate for their standards is so that the regulated professionals might retain some degree of freedom and control over the practice of their profession. So it seems like, apart from the copyright issues, there might be a tension between that self-regulatory freedom and the need for access to standards that the government has incorporated by reference.
I'm not sure I see the tension. When the government chooses to adopt a standard, it still doesn't preclude industry groups from engaging in self-regulatory conduct that goes beyond what the government's requiring. I feel like I want to see the text of the question again, but it's disappeared.
If you go to answered.
Oh, okay. But I think the point, as I mentioned earlier in this discussion, lots of times these organizations will actually go to the agencies and say, look, we think we know the right way to tackle this problem. Government agency, we want you to make what our standard into the content of the law. And I think once that happens, or once the government adopts any text into the law, it's critical, no matter who you are, to be able to see the text of the law without having to overcome the obstacle of a paywall.
I just want to note that this was something that was addressed by the court in Veek, the Fifth Circuit en banc case, where they talked about how organizations can actually have a self-interest in having their, getting to decide and be the ones to create the standards that are then incorporated into law.
And on that point, it's not, I believe it's ASTM, but I might be wrong, but I believe it's ASTM that, and I'm sure others might too, marketed in the part of their marketing for their membership is that they create these standards that will become binding law. And so sort of an advantageous part to paying the membership fees to ASTM is that you get to have a hand in making law. And which one other practical problem we didn't quite touch on, but Professor Peter Strauss from Columbia Law has found some standards, and one of the CPS standards that NCLA has commented on during notice and comment rulemaking, the standards that do become adopted by law, these standard setting organizations are charging a premium for the standards that have become binding law. And so if, say, the 2016 version is incorporated by reference, and there's an updated 2019 version that has not been incorporated by reference, the standard setting organization is charging more for the older, out-of-date version because it's still binding law. And so part of the problem is that the government has created a monopolistic pricing system for these standard setting organizations. And with that, I think we're just over our time. I want to thank Adina and Professor Mendelson for being with us. I thought it was a fun and interesting conversation. Thank all of the attendees for joining us.
Thank you very much.